Let's talk about how the eviction process works in the state of North Carolina. So hopefully you have a signed lease, because if you don't, it makes the process a little different. But we're going to assume that you have a signed lease in the property, that the tenant is late on the rent and probably substantially late, more than 10 days, and they're not paying the rent. They're probably not going to pay the rent, and you know that something needs to be done. This can be a very stressful situation. Take a breather, and we'll walk through the process to make this easy for you. Obviously, we want to be humane about this, and we're not doing this to be mean, but you have a mortgage to pay, and you can't make that payment if somebody else doesn't make the rent payment. So we understand that there's a practical side to this, as well as a human component. And so we do this with compassion. We do this not in a vengeful manner, but we do it nonetheless. The first thing you're going to need to do is you're going to need to file complaint and summary ejectment. We worked in the greater Wilmington area, so we cover New Hanover, Pender, and Brunswick counties, and we are most familiar with New Hanover County. You're going to file the complaint and summary ejectment. You're going to pay a fee to the clerk of court, and there's a couple other forms you're going to need to provide as well. One is the magistrate summons, and one is the Civil Service Member Relief Act affidavit. That's a mouthful. So essentially, for military personnel, we have to ensure that we can verify, we may have to attest or swear that we know whether they are or are not in active military service. So with those three pieces of paper, we're going to go and we're going to file all these with the clerk of court. The sheriff is then going to deliver notice to the tenant that they are being sued in small claims court. It'll list the court date, and the sheriff will physically go to the door of the property. And some municipalities, it may differ. All the laws in North Carolina are consistent, but certain counties may administer them with some variance, and there could be some nuance. Theoretically, they are all going to be done the same. In practice, however, they're not. The good news is that in many cases, when a tenant is visited by the sheriff's department with notice that they're being sued, if they have the means to pay the rent, they probably are going to. In many cases, the process stops here because they recognize that we're not going to let this go on indefinitely. They recognize that you're going to follow the process, and they're not going to be able to just skate through. In many cases, this may be the end of the process, and you'll quickly receive payment. However, we'll continue to work our way through the process in the event that they're unable to pay or maybe choose not to pay. People frequently ask, how long does this process take? Is this going to be months? Is this going to be a year? Fortunately, we're not in California or the Northeast. We have North Carolina is fairly landlord friendly. In many cases, this can be resolved within 30 days. So there's some exceptions, but that in general, this process can be resolved within 30 days, maybe even sooner. We're now at the court date. We're at the courthouse. We're in small claims court. We're standing in front of a magistrate, judge, and we present the facts, what the rent is, when we received rent. The tenant may or may not be in attendance, and that does have some impact on how the situation goes. If the tenant is not in attendance and was not personally served the notice, then there will be no judgment issued. You can still be awarded possession of the property, but you won't be awarded a money judgment. So it is better that the tenant does appear in court to defend themselves for that reason. Let's say that the magistrate rules in your favor and agrees that X amount of dollars is owed. The tenant is going to be given 10 days to pay that balance owed. They may choose to vacate the property or to appeal the case. Generally, don't see many appeals made, and part of the reason for that is because there's additional costs incurred. They are, in fact, required while you're awaiting trial in Superior Court to continue to make rent payment to the clerk of court, or the landlord can get possession of the property. So that's important to note, and for that reason, we don't see a tremendous amount of appeals, in fact, very few. After 10 days, assuming the tenant has not paid the monies owed and they have not moved out of the property, then you would now file the writ of possession. And you're going to take this down to the courthouse like before, and you're going to deliver this, you pay a fee as well. It's less than the first time when you file. The total filing charges initially is $126, and this time it's about half that. You'll file that, and the Sheriff's Department will again deliver notice that the writ of possession has been issued within a number of days. The sheriff is going to show up at the property along with property manager, homeowner, landlord, and a licensed locksmith to change the locks and do a lockout. At this point, you would go with the sheriff to the property. They'll ensure that the house has been cleared, that nobody is actually in there, children, pets, make sure that nobody's in the property. If they are, they're actually going to be removed from the property, and the locks will be changed, and now you have possession of the property. There are some other considerations to be made. If personal property is still left in the home, as it often is, if the value of that property is deemed to be $500 or more, you will be required to keep that in the property for 7 days, allowing the tenants access to come and remove those items during normal business hours. And at that point, after those 7 days have expired, the property no longer belongs to them, and it can be disposed of, sold, given to charity. A variety of different options can be exercised there. There is a limited exclusion to the law to allow a property manager to act on behalf of a homeowner in eviction-related matters in small court. If you find yourself in a situation where you have a property that you're managing on your own and you don't know how to handle it, if we can be a resource to you, please let us know. Please reach out. If we can help you in any way, please visit our website, submit a general inquiry, and we'll be in touch with you to see how we can help you in this trying circumstance.